don't have anything else unless there's any other questions.
Any further board discussion? Any public comment? Thank you, Sarah.
Thank you.
Our next order of business, we're going to go back to agenda item number 18. The ledge report with Brooke.
So as noted on the 2016 legislative calendar, which were included in the meeting materials, the legislature reconvened August 1st from summer recess. September 30th is the last day for the governor to sign or veto bills that have been passed by the legislature before September 1st and that are in the governor's possession on or after September 1st. All statutes will take effect January 1st, 2017. We'll go ahead and move to the 2016 legislative summary, where I'll provide a brief summary on all bills and status updates. On the first page of the legislative summary for AB 12 and AB 507, AB 12 is the Administrative Regulations Review Bill, and AB 507 is the Breeze System Annual Report Bill. We haven't seen any action taken on these bills since August of 2015. On page 2 of the legislative summary, AB 2744, which is the Healing Arts Referrals Bill, has been updated since the meeting materials and was amended on 8/23 by the Senate. Mainly, the amendments on this bill were just for clarity and technical changes. And currently, this bill is in engrossing and enrolling. Moving on to AB 2859, Retired Category Licenses Bill. This was recently amended on August 3rd, and these amendments were included for the board's review in the meeting materials. This bill authorizes any of the boards within the department to establish by regulation a system for a retired category of license. This would not apply to a board that has other statutory authority to establish a retired license. Today, the Assembly concurred with the Senate amendments. We'll further discuss this bill under the rulemaking report, agenda item 19A. SB 1155, Professions and Vocations Licenses Military Service, is dead as of 8/12/2016, as it failed the deadline pursuant to Joint Rule 61B14 in the Assembly Appropriations Committee. So that's a recent status update as of the 12th of August. And SB 1195 language was carried into the new bill SB 1194, which was provided as a handout. Shelley Jones from the department updated members today that the proposed language was pulled. So we'll go ahead and staff will apprise members of any status updates related to legislation regarding the North Carolina Supreme Court case. And the last bill on the legislative summary, SB 1348, licensure applications, military experience, was signed by the governor and chaptered on August 22nd. So that's a recent status update on that bill as well, which is different from what's in the meeting materials.
Any questions from the board? Any public comment? All right, let's move on to your rulemaking report.
Okay, so at the November 2015 meeting, the board adopted the 2016 rulemaking calendar, which sets forth all of the board's rulemaking items for the year. Going directly to the rulemaking tracking form, the first item on this form is the English proficiency regulation. The rulemaking file was submitted to the Office of Administrative Law on June 16th and was disapproved on August 5th. OAL provided a decision of disapproval, which gives the board 120 days to correct the rulemaking file to address their concerns, which will be further discussed under agenda item 19C, where proposed language will be presented to the board for your consideration. The second item on the rulemaking tracking form is the retired license status regulation. The board approved language and forms at the May 2016 meeting, and those are included as a handout. During the 45-day comment period, the notice was withdrawn from OAL per advice from the board's legal counsel. They did have some concerns on whether the language met the authority, consistency, and clarity requirements. After the notice was withdrawn, it was brought to the attention of staff at the board that the board's authority in Business Professions Code Section 2648.7 may be limited to only exempting the renewal fee and continuing competency requirements, and doesn't give the authority to establish a retired license status. AB 2859, as discussed during the legislative report, was recently amended after the board withdrew this regulation, the notice from OAL, and it provides the board the authority to promulgate regulation based on if that bill goes through and is signed by the governor.
So, we're going to talk about it when we get to our language, though? More?
Yes.
Okay. That can wait.
And the additional rulemaking items noted on the tracking form were approved per the rulemaking calendar in the 2016 rulemaking calendar, and we're in the process of researching a lot of these items, or we'll also be addressing them in our sunset review report as well.
Any comments or questions from the board? Any public comment?
Just a question of presentation, if you will. So you might notice a significant change in the way this data is being reported to you, as far as graphic and that kind of thing. And it was done with the intention of making the information a little bit more intelligible, easier to understand. And if the board could provide any feedback into what they think in presentation or anything that you'd like to have added to it, we would appreciate it.
I think it's definitely an upgrade. It was a lot more clear to watch it move across the timeline. So thank you.
I think the only thing that's lost, I like it too, it's really clear. The only thing that's lost is to know what the steps are that are ahead.
So I think
That's what bogs it down.
we've identified that the next time we produce this report, the very first timeline will be more of a guide, the general steps, if you will, and then you'll have that to compare to.
All right. Is that all you had, Brooke? Or do you wanna
Yes,
move on?
unless you want to go to 19C,
I think we're ready.
So as I stated in the rulemaking update, the proposed English proficiency regulation was filed with OAL on June 16th. And on August 5th, the board received the decision of disapproval from OAL, which outlined minor procedural issues and determined that the regulation failed to meet the consistency, clarity, and necessity standards that were further addressed in the briefing paper. For the board's consideration, staff are presenting proposed modified language. These modifications to the proposed regulatory language are substantially related to the originally noticed language, and therefore the changes can be made within a 15-day notice of modified text. The board has until December 3rd, 2016, which is 120 days from the receipt of the decision of disapproval, to resubmit the file to OAL for their review. If we want to go ahead and go to attachment 1, which is the proposed text, the language which includes FSBPT's 2018 TOEFL requirements.
And just to clarify, where we are in the agenda book, page 94?
Page 94, correct.
Thank you. And the proposed additions are underlined and deletions are crossed out in red?
Correct.
Correct.
Thank you.
So as you see under 1398.25, subsection C3, that is the first modification in the language. In addition, under 1398.26.3, the scores have also been updated to reflect the 2018 FSBPT's new minimum requirements.
A question about that, the B in that section. I actually don't understand the sentence.
Under 1398.26.3, a foreign applicant
Yeah.
who graduated from a college, university, or professional training school in Australia, Canada, etc.
Yeah, what does that mean?
So this was kind of a chicken or the egg argument with the OAL attorney. There is no authority in the statute for the TOEFL requirement as a result of SB 198 to provide for an exemption. There is language that says we can refer to the TOEFL examination as administered by ETS or some other examination as created in regulation by the board. And so with the guidance of the OAL attorney and trying to anticipate what it is that we were trying to achieve, her recommendation was that graduation from an English-speaking school or a PT program in an English-speaking school should be enough proof to suffice that they are proficient in the English language. Same outcome.
But the way it reads up above is whether the foreign applicant achieved the minimum required score in accordance with 1398.26.3. So and then A describes what that is, but I don't know what B means. I don't know what that means. That means that you have a passing score?
It's an incomplete sentence. Where A says that the foreign applicant must demonstrate proficiency and then by achieving those scores, but then B just, yeah. It doesn't say,
B states a foreign applicant.
The last line shall be
It looks like
considered.
the last
it's not
line
stricken
should be in,
through.
should be in
Mhm.
black instead of red. They left it red.
thank you.
Wait, no, I read that. No, I'm reading the whole sentence, but I don't know what that means. I don't understand it.
It means they don't have to sit for the TOEFL.
Well,
I
it
think
says that they've achieved the required score within a single administration of the TOEFL in accordance with the section. So it still, to me, means they're taking the TOEFL.
I don't see that same part that you're looking at, Deborah.
Whether
think I-
the
I think I see the disconnect. So where we say they must demonstrate English proficiency, and we go on further to state by achieving the following minimum scores within a single administration, and then state what the scores are. Is B specific enough to counteract that request or that requirement by stating that a foreign applicant who graduated from a college, university, or professional training program in those English-speaking countries shall be considered to have satisfied proof of English proficiency.
I'm wondering if perhaps just underneath the title of the section, if the phrase is put to determine English proficiency, colon, and then it's either A or B. That, because otherwise it's just English proficiency as determined by A and B, because there's not an or. Or to determine English proficiency, the applicant must meet one of the following.
Or if 3 didn't mention TOEFL, but said had demonstrated English proficiency, then that would make sense to me.
Pursuant to
that regulation
1398.
specifically, yeah.
But the fact that it mentions the single administration of the TOEFL up above is what's makes B not make sense to me.
So must demonstrate English proficiency by either achieving, and then have that section still stated as it is now, or graduated from a college, university.
Approved by the board. Because you have in the 1398.26, the language. Sorry. Or, so when I read 1398.263 English proficiency, the second sentence there tells me, not approved by the board and is not located in the United States. Well, these are the criteria. Now, B tells me that the board has approved this scenario here, right? The one who graduated from a college, university, or professional training school in Australia. So that, I know it's semantics, but
I think the important part of approved by the board is to map out either the CAPTE accreditation or the foreign application process. So when we say an education program not approved by the board and not residing within the United States, that is just to define a non-CAPTE accredited graduate.
right, and that's why to me, in the 1398.26.3 sub B, I'm going to infer that has been approved by the board, right? Because that satisfies the English proficiency requirement, or am I?
For only this particular requirement,
Right.
for English proficiency itself.
Right.
So the addition of, I'll let legal chime in on that if that's something that,
Yeah.
for clarity, would need to be added.
Can you please state or repeat your proposed modification?
Mine?
Correct.
I'm not sure I proposed anything. I was just trying to think it out loud in my head here.
So I actually wonder, I think I might have a proposed change, that we move the A in parens and start off English proficiency, and then the first line, in accordance with section 2653 of the code, an applicant who graduated from a physical therapist education program that is not approved by the board and is not located in the United States, a foreign applicant, must demonstrate, A, English proficiency by achieving the following minimum scores: reading, listening, writing section, speaking section, or a foreign applicant who graduated from a college or university training school in one of those locations shall be considered to have satisfied proof of English proficiency.
So then, keeping with what you have, in accordance with section 2653 of the code, an applicant who graduated from a physical therapist education program that is not approved by the board and is not located in the United States must demonstrate. Then we start off with our first A, English proficiency by achieving the following minimum scores within a single administration of the test as English foreign language with those numbers. And then B,
So an or B,
or, comma,
because otherwise it's implied that they have to do both.
must demonstrate A, English proficiency, or B,
We could remove the foreign applicant.
Thank
We
you.
could say,
That's
have
better.
graduated from a college,
must demonstrate graduation from,
university, or professional training school in one of those locations.
and then we can get rid of shall be considered to have satisfied proof of English proficiency, because that would be repetitive from what you just, okay.
I would recommend putting either under the first sentence and eliminating or, just for consistency with regulation language. So
Noted.
it would be in accordance with section 2653 of the code, an applicant who graduated from a physical therapist education program that is not approved by the board and is not located in the United States must demonstrate English proficiency by either colon achieving, so then insert subdivision A, achieving the following minimum scores, and then at paragraph 4, putting a period after 24, and then subdivision B would start up.
Graduate from.
Graduated from, yeah. Or graduating from, to be consistent with achieving.
And then is there any, I like that. I think that makes it more clear. And then is there any conflict with 3 still referring to, I mean, to me, it's really, it should state
I agree.
achieve, or that they've achieved English proficiency or demonstrated English proficiency.
Yeah, I'm rereading that, Deborah, and I think I'm seeing what you are seeing, because the very first sentence in that section ends with meet all of the following criteria. Right? So that doesn't account for individuals that we would not require the TOEFL of. Would addressing that fix it somehow?
It needs to be fixed. So it would need to say whether the foreign applicant demonstrated English proficiency in accordance with 1398.26.3.
Yeah.
So you strike achieved the minimum required scores within a single administration, because all of that language is under subdivision A, under English proficiency.
Is there any, Jason, is there any, you guys have worked with this much longer, is there any weakness that creates in that section of 1398.25?
No, I don't think it does anything but bring a little bit more clarity.
Okay.
Do you need a motion to adopt this language as amended? No?
But we will, we can leave it on.
Okay.
Yeah.
We have council read it back to the board so we can.
Yeah. Well, first off, part of the OAL's notes in rejecting the package was that the board did not ratify the proposed modified text that was in the final rulemaking package. So the board will need to ratify the proposed modified text dated November 25, 2015. That'll need to be our first step, which is the current language as you see it without the revisions we just discussed.
This is a housekeeping measure.
Yeah.
Move to ratify the previous proposed language.
Second. Any further board discussion? Any public comment? Roll call vote, please.
Katerina Ellaby,
Aye.
Alicia Rabina-Amen,
Aye.
Deborah Alvizo,
Yes.
Jesus Dominguez,
Aye.
Daniel Drummer,
Yes.
Tanya McMillian,
Aye.
TJ Watkins.
Aye.
Thank you.
The vote was unanimous.
Okay, so
Thank you for that, Sarah.
so the proposed modified language for TOEFL will now be in 1398.25 subdivision C, paragraph 3 will be revised to state whether the foreign applicant demonstrated English proficiency in accordance with section 1398.26.3, period. Then moving to proposed regulation 1398.26.3 for English proficiency. The language would remove the parend A at the beginning of this first sentence. So it would start off with, in accordance with section 2653 of the code, comma, an applicant who graduated from a physical therapist education program that is not approved by the board and is not located in the United States. And I don't believe we're not using a foreign applicant, we're striking that. And is not located in the United States must demonstrate English proficiency by either. Would you like to add the following, colon, either the following? Or is either, colon, sufficient? Anyone have a preference?
I think either by itself is pretty clear.
Okay. By either, colon, subdivision A, achieving minimum scores within a single administration of the test of English as a foreign language, paren TOEFL. All right, so I think here we need to say achieving the following minimum scores within a single administration. So this is subdivision A, achieving the following minimum scores within a single administration of the test of English as a foreign language, TOEFL. Then paragraphs 1 through 4. So paragraph 1 is reading section. 22. Listening section for paragraph 2 would be 21. Paragraph 3 is writing section 22. Paragraph 4, speaking section 24, period. Then new subdivision B would read, graduating from a college, university, or professional training school in Australia, Canada, except Quebec, Ireland, New Zealand, the United Kingdom, or the United States, period.
Do you need the United States? Does it contradict what's up above? Not in the United States.
That might be carried over from the federal regulation.
It doesn't bother me. I'm just curious. And then up in A, the test, should that be capitalized? It is up above, or it was before we changed that language.
Yes,
Okay.
the capital T on test. And so then the revised subdivision B would read, and I'm at the end of the sentence, would be New Zealand or the United Kingdom, period. I went back and read that. This is out from, but then I read, must demonstrate English proficiency by achieving the following minimum scores. Yeah, I went back and reread that. Did you read that? Said the following? Okay.
Is there any time that there would be a not approved by the board but located in the United States that would need, I'm wondering
I
if
think-
that belonged there for some reason.
I think that is it's a possible consideration, but 2653 clearly states not located within the United States. So it is kind of a circular reference that we should be concerned with. But I think there was a purpose that there may be some schools that don't achieve CAPTE accreditation, if you will, that this might allow for some discretion. But I'm comfortable removing it.
Sorry, I missed the first part of the question because we were speaking. So you're referring to striking United States.
I was referring to that and whether there was any combination of things that we were trying to capture. I couldn't.
And I would recommend striking it because when you do it, we're still going to have to actually justify. The staff is going to have to justify why it's in there. And if at this time we can't explain why, there would not be a basis to necessarily support that one.
Sarah, did you have a comment?
I do. I think it was included for someone who's educated from a non-accredited program who may have attended like a transitional program in the United States. They've went through that process, so I don't think they would have to comply with the TOEFL requirement because they were educated at a certain level here in the United States.
That's a very good point. So a transitional DPT program where the core of their education is outside of the U.S., which makes them a foreign graduate, and have to apply to 2653, but they have graduated from a CAPTE accredited transitional program. Proof of graduation of that transitional program, including the United States, would include that, and we would have what we need to identify it as rationale in the package.
When I go back to the code, section 2653, it starts off, an applicant for a license as a physical therapist who has graduated from a physical therapist education program that is not approved by the board and is not located in the United States shall do all of the following.
Mm-hmm.
So right there, we're already saying not in the U.S.
Right. So, and I'm going to step back just once to kind of bring maybe hopefully a little clarity. And that would still be the case. They might have achieved what we would equivalent to either a bachelor's or a master's degree in physical therapy or physiotherapy in their home country. But after they've come to the U.S., not only have maybe a doctorate transitional program, but maybe a business degree for that matter. Some kind of educational program where they've demonstrated English proficiency could be considered with that language included.
And so the reference to 2653 in the beginning of this section is where, when it says who graduated from, I'm sorry, that specifically states their physical therapy education.
Mm-hmm. And you may still have that same scenario where they are a graduate from a physiotherapy program in India, if you will, but they've also achieved a doctorate transitional program in the U.S. They are still a foreign graduate. The core of their education has to be considered for equivalency. But the proof of graduation of the doctorate could be proof of English proficiency.
And so if someone then came here and, like you said, had a business degree,
Mm-hmm.
are you thinking B would apply to them?
I think it could.
Well, do we need to make it clear that graduation from one of these colleges isn't specifically tied to the physical therapy program?
In A, it does say who graduated from a physical therapy education program has to take the TOEFL. Right?
Mm-hmm.
So the
So-
discrepancy comes from if they took a
I think-
TDPT.
I don't know if it's a discrepancy as so much as that we're talking about two different things. So one is credentials that should be evaluated for equivalency as far as the practice of physical therapy. And in that case, we very much would require that it be a physiotherapy or a physical therapy program in their home country. But English proficiency is a broader topic.
Okay, so this foreign applicant is probably going to, let's just say that they're going to be using the Coursework Tool 6,
Mm-hmm.
and the TOEFL's part of Coursework Tool 6, isn't it?
Not directly. So TOEFL Well, for the Federation coursework, 206 will be incorporated into it. For us, because we'll have a separate statutory requirement with TOEFL, it would still apply to also 1 through 5.
So I'm wondering if the language in B, from a legal standpoint, when it refers to graduated, if it, because it's in accordance with 2653, if it's still referring back to physical therapy education and the business degree has nothing to do with it.
Right, I think we would need to add some language at the beginning of subdivision B to specify graduating from any type of program
Then it gets
See,
real
and I
bad.
at
think-
a college.
And I think,
Yeah,
I guess I'm seeing it just the opposite. If I wanted it to be a physiotherapy program, I would state it and be one who graduated from a physiotherapy program from a college, university. What we've done now is we've made the language broader.
And I think the ultimate question is for the board,
Is it clear?
is if you're going to consider applicants, if you want to set a specific standard for them to be English proficient, do you want to set that standard that you're okay if they graduated from any school or program or college, or that you're going to find them proficient in English if they only graduated from a particular physical therapist education program from these countries? So where does the board feel that they're comfortable if any of these countries in either scenario?
I think, I mean, personally, when I'm reading, if I think about it from the real broad sense, it's on. Then professional training could be any kind of program that someone would. So if the importance is to determine English proficiency, then we may still be talking about physical therapy education in B.
And you could be, but what does the board feel comfortable with actually setting the standard at? So that's what I'm trying to find out. What's the standard you want?
Right.
Then we can
That's
decide
what
how
I'm
to.
stating. Sorry, that's what I'm saying. What I would be comfortable with is maybe not having it be so broad.
To have it limited to graduated from a physical therapist program in these countries?
That's what that's if that.
Is
That's
that-
what we're kind of saying.
I agree.
Any comments from the public members?
Well, maybe, when we broaden, if English proficiency is its own standard, and you limit it to the physical therapy, what would be our primary reason for doing that? Just a question.
Consumer protection, I think. Proficiency in English in your profession is very important. Being able to speak, write, understand, and communicate in English, physical therapy language is very important.
Topically to physical therapy.
So is it, you see, because why I'm asking that is because they are a separate standard here, currently in California. When we move to the coursework tool 6, they become one. And then automatically it falls within that physical therapy. So if we narrow the language, then we fall in line, obviously, with the coursework 6.
Yeah.
Is
Just-
that where we're going? We want to be consistent with those coursework 6 of the futures.
Just to be clear, though, the regulation of licensure in California will never be driven by decisions or actions made by the Federation of State Boards of Physical Therapy. So with the example of moving to Coursework Tool 6, that's ultimately a discussion we're going to have as a board, but by no means is the decision made because it's been made by the Federation. I just want to make sure that we understand that clearly. If that happens to be the case where Coursework Tool 6 is an eligibility requirement, but this board determines that it's not something that we can abide by as a requirement for licensure, that's a separate discussion that we'll have to have and deliberate on, and how we communicate that to the Federation and what decisions need to be made. But I do agree with the idea that there is the consideration of equivalency for physical therapy education. That is one component of this equation, and then the second being the proficiency in English. And when I think about this standard and where it comes from. It doesn't apply specifically to physical therapy. It's spread amongst other healthcare boards as well as other licensed practitioners for immigration standards, if you will. But I appreciate the idea that it is contextual, that we should consider English proficiency in the profession or in the practice of physical therapy. I guess the question really is at that point, if it being as broad as it is stated currently, and as an example that it's a business degree or any other kind of degree that you might be able to imagine, would that lessen English proficiency in this portion of the application?
I tried to do some looking at the other pieces of legislation of the law that look at education, and I'm wondering if 2650, which addresses the physical therapist education requirements, and number one, if that might satisfy the issue as far as what the education needs to be in. Number one reads, except as otherwise provided in this chapter, each applicant for a license as a physical therapist shall be a graduate of a professional degree program of an accredited post-secondary institution or institutions approved by the board and shall have completed a professional education program, including academic coursework and clinical internship in physical therapy.
Mm-hmm.
So somebody who has a business degree wouldn't necessarily be able to apply for licensure because they haven't satisfied the physical therapy education component.
Yeah, so I'm looking in addition to. So they would have that, but they didn't, as, again, I'm going to use the exemption word because that's what's really at hand here, even though we're not calling it an exemption, we're calling it a suffice the requirement. They have that physiotherapy education from a foreign country. That component is there. But they've also now, residing in the U.S. or residing in one of these English-speaking countries, also achieved, and when I say their physiotherapy education, I mean in a country that is English as a second language, so India, Pakistan, or something like that. But then they moved on to one of these listed English-speaking countries and achieved a degree of some kind from either a college, university, or professional training school. In a very broad sense, would that still satisfy just the English proficiency requirement alone?
Well, that's a very interesting one, because if that were to happen and they were going to be accepted in any U.S. program, they would have had to satisfy a TOEFL requirement to enter any of those programs.
Correct.
So they
may have a score.
They may have a score.
That score may not have the same pass settings that we've determined here. And the other issue at hand is how old the score is at that point. If it was more than 2 years ago, it becomes an issue with us being able to attain that score or validate that score with ETS.
So in an inadvertent manner, we kind of answer that question, because now we have to narrow it for the profession. Because if the business school can narrow it, in your example, for their profession, then we kind of, there's a kind of you can infer standard.
Sure.
And if we don't infer that standard, then we wouldn't be able to, it will narrow it to the very specific.
That's a very good point.
And we draw very distinct lines as to what the physical therapy profession entails in the U.S. So I think that will probably.
I think Mr. Watkins has helped me satisfy my own question, curiosity.
Unintentionally.
I think I appreciate it very much so.
So are we considering adding physical therapist education program to be? Okay, so I'm going to reread subdivision B. This is under new proposed regulation 1398.26.3 subdivision B. graduating from a physical therapist education program from a college, university, or professional training school in Australia, Canada, except Quebec, Ireland, New Zealand, or the United Kingdom, period.
So then there's just one question left as a variable, and that is those graduates of transitional DPT programs that are CAPTE accredited. Is there reason to believe at that point that they are proficient in English, at least to these standards?
I think we would need data either way. But for consumer protection purposes, we'd have to assume no, unless we have data.
I have a question.
Deborah, your fingers up.
Up in the lead-in to A is the same phrasing of the physical therapist education program. And I think it's clear to have it in B, but I'm just wondering if that creates is that any problem, or is it just clearer?
I believe it's clear. Thank you.
So Alicia, you're proposing that we leave in the United States as well? Is that what you were saying? No?
No.
Okay.
So I think, Jason, part of what you're saying, I think what you're recognizing, there's lots of scenarios out there that are happening.
Absolutely.
right now. And really, what we're trying to capture is the people, what's kind of the real capture of demonstrating that. There may be some people that we've identified that are in the testing category, and it will not be a challenge for them to. There may be some people
Right.
that end up in that category.
And it is very much from a, I'm going to coin a phrase today, from a North Carolina perspective. So what I'm actually battling with, and I've already kind of, with the help of Mr. Watkins, kind of satisfied my own curiosity, is that what I would be doing is requiring a CAPTE accredited DPT transitional program graduate to still take the TOEFL. And that is consistent with every other requirement that we have at that point.
But CAPTE does not approve the T DPT programs. The transition component, the transition
I see what you're
program
saying.
component
My
of
mistake. Same scenario, though. I wouldn't be providing any allowance or accommodation to a graduate of a transitional program that isn't accredited. I would still be equivalating them as I would any other graduate, and they would have to take the TOEFL.
Which is another good reason to take out the United States in that
Right.
be, yeah.
You want to read it back one more time?
Okay, so the proposed modified text that we're considering for adoption is Regulation 1398.25, Subdivision C, Paragraph 3, would be revised to read, whether the foreign applicant demonstrated English proficiency in accordance with Section 1398.26.3, period. Then new proposed regulation 1398.26.3, English proficiency, would be revised to read, in accordance with Section 2653 of the Code, an applicant who graduated from a physical therapist education program that is not approved by the board and is not located in the United States must demonstrate English proficiency by either, subdivision A, achieving the following minimum scores within a single administration of the test, and we're doing a capital T on test, of English as a foreign language, TOEFL, paragraph 1, reading section 22, paragraph 2, listening section 21, paragraph 3, writing section 22, paragraph 4, speaking section 24, period. Subdivision B, graduating from a physical therapist education program from a college, university, or professional training school in Australia, Canada, except Quebec, Ireland, New Zealand, or the United Kingdom, period.
Did you say or? Yes. Okay, thanks.
What was that? I missed that.
Before subsection B, was there an or?
No.
Because it was either of the following.
Okay,
or
by either A,
Mhm.
B.
B, yep.
I have a question if there needs to be a comma between Canada, parentheses, except Quebec.
I don't think so. We could take that comma out.
Thank you.
So before the board votes on this language, we need to discuss the reasoning behind changing these test scores. We're going to need to document that thoroughly in the amended issue statement being submitted with the final rulemaking package. So we're hoping to get your feedback on whether or not you agree with changing these scores.
The rationale of which was provided as an attachment to the agenda item. Another point of that's noteworthy is that those score changes that FSBPT had proposed became effective July 26th of this year. So they're very recent changes. And we have just now received this justification in time for this meeting for your consideration.
Jason, where's that attachment? I'm sorry.
Page 92.
Thanks.
And just another note, in conversations with the OAL attorney as to whether or not it was appropriate to still include these changes, she agreed that it was very much substantially related and to the spirit of the promulgation of this regulation from its inception.
So I guess on some level, is it appropriate? Does the board find it appropriate to rely on this ETS study that's provided on or discussed on page 92? Is that a reliable source of information that the board feels comfortable adopting the FSBPT standards?
Does the board have any concerns about the FSBPT's justification for the increase in the score?
There is no overall, I just want to be clear, there is no overall increase in the score. It's still an 89, but it is a recategorization where some points have raised, some points have also lowered.
Thank you, Jason.
Also, the panelist that was on the, I'm just questioning, the FSBT process. The panelists, did that include anyone from California, or how did they comprise of the panelists? I mean, I'm reading, they're coming from all different, I just want to see how much participation was from, this is all experts, I'm assuming.
I'm not aware that any of the subject matter experts in this panel were California licensees. Licensees of physical therapy, but not from California.
My immediate tendency is always just to question, just for the sake of questioning.
Sure.
I have no issues with the justification. Does any of the board members have any comments? Do we want to do a straw poll and see how each of us feel? No. That's fine, okay.
Fine.
Deborah?
I'm fine with that.
I'm fine with it.
No problems.
I'm good with it too. Okay, so does legal counsel have what they need for us to move forward with a vote?
Yeah, I just wanted to raise two things. One is we probably need to make sure that Appendix A is included with the final rulemaking package, since that is now,
Documents to be relied upon.
reasoning behind adopting the new scores. But I also wanted to point out on page 2 of the proposed modified text, in the authority cited, it shows that we're taking out the federal regulation. I just want to go ahead and make sure that everyone's aware that we're going to make that change as well, since we've significantly revised the rest of the text. I just want to include that.
Can you explain the impact or the need for that?
Yeah, we need to take out the cite to the CFR, the federal regulations, because that cross-reference kind of started the whole problem with needing to reference that federal regulation, because we were incorporating the text, but in obviously an improper way. So now that we're no longer referring to it in any way, we need to strike it from here.
Okay.
So it's just a clarity issue.
I think that's appropriate.
And you're talking about the reference to CFR that's on, I believe it's page 89,
95,
95.
95.
the proposed language
That's correct.
itself.
Okay. I move that we approve the proposed modified text for a 15-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes as modified if there are no adverse comments received during the public comment period, and also delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file.
Second.
Any further board discussion? Any public comment? Roll call vote, please.
Katerina Ellaby,
Aye.
Alicia Benamian,
Aye.
Deborah Alviso,
Yes.
Jesus Dominguez,
Aye.
Daniel Drummer,
Yes.
Tanya McMillan is absent, TJ Watkins.
Aye.
Thank you.
The vote was unanimous. I think it's a good time to recess for lunch.
It's very good timing.
We do. Does the vote note that we did have one board member
does.
missing? Okay, thank you. We will be back at 1 p.m. Thank you. We are reconvening from recess. The time is 1:04 p.m. And we're going to continue with agenda item number 19B, discussion of issues regarding license renewal exemptions for retired status, statutory and regulatory language, and possible board action.
Okay, going back to the retired license status regulation, please refer to the handouts with the proposed language and forms that were adopted at the May board meeting. As discussed in the rulemaking report, during the 45-day comment period, the notice was withdrawn from OAL per advice from the board's legal counsel on whether the proposed language adopted at the May board meeting met the authority, consistency, and clarity requirements. After the rulemaking file was withdrawn, SB 2859, which was also included in the meeting materials, was amended and staff revisited the language of the bill. The board's authority in BPC section 2648.7 may be limited to exempting the renewal fee only and does not give the authority that AB 2859 would give through the new language in the bill for Business Professions Code 464. At this time, staff is of the opinion that the language in AB 2859 gives sufficient authority for retired license status should this bill be signed by the governor. Staff will need direction from the board on how to proceed with this rulemaking file.
I think one of the important distinctions to make here, though, is that the withdrawal of the file didn't really have anything to do with this new amendment to the legislation. It was more a conversation and kind of an epiphany with the help of counsel that I had gone outside of my delegated authority and made a substantive change instead of a non-substantive change in proposing the regulation. Specifically, the authority to require documents certified as part of the application process in the event that they had criminal action. I anticipated that being an issue with authority, so I took it out. But in taking that out, I overextended the authority that you granted me. So that compiled with a couple other edits that legal had suggested that we made the decision to withdraw the package. And then subsequent to that decision, this legislative bill was amended to include some new authorities. But as part of that conversation that we were having with legal, we realized that our exemption as a result of SB 198 is, again, another one of those kind of chicken and the egg situations where it doesn't expressly state that we have the authority to issue a retired license. It just says if you have a retired license, you could exempt them from the renewal fee and the continuing competency requirement. So we are in a kind of new situation given the circumstances.
So if the understanding of what we have existing is that limited, then the bill that's up currently will apply to us?
It could.
Actually, the bill that's up right now, 2859, specifically excludes boards that have their own statute with respect to retired licenses. So there's only one provision of that bill that would apply. And unfortunately, the stuff that we would actually, probably benefit from, like the ability to charge for the processing of a retired license, that's in the bill. That would not apply to us. And there's one other piece. I think certified copies of criminal records, that would not apply either, which was one of the main issues with the regulation package, whether or not the form itself could require certified copies of a criminal history.
Where in this is the certified copy? Is it in the application, or is it?
Well, that's one of the issues at hand. So the language that you have before you is the language that we submitted to OAL, but that is where the more than substantive change occurred. So at the adoption, at the meeting in May, I believe, the discussion entailed including that authority. And I made the decision outside of my scope of authority to remove it, which would be considered a non-substantive change. Or a substantive change, I'm sorry.
Remove it from the regulation itself, but it was still on the form.
As an ask.
Does the board have any comments about the newly proposed language?
Well, the language that you have before you is the language that was previously submitted and then withdrawn because of the problem.
I see.
So I guess And there is a discrepancy, I guess, if you will, or a disagreement of whether this new piece of legislation applies to us or not. Tara will tell you that it's her opinion that it doesn't. When I read our exemption status, it specifically speaks to the renewal status and as an exemption of a fee. I can't really go through my Practice Act and find something that grants me the status to actually issue a retired license.
So at this point, is there a recommendation that that any language about this just be held? I mean, it seems like we will need
So,
some at some point.
As far as alternatives go, so you could take the language that we have set forth that I did not give you the opportunity to adopt in the abuse of my power, and you could adopt it, or we could amend it again to include that 30-day certified copies clause. And then the other alternative to that is to ask, does this new piece of legislation provide maybe solutions to some of the other problems that we identified as far as an application fee into and an application fee out of retired status and those kind of things?
And if it does, then
We would have to wait for that bill to become codified, chaptered, and then cite that as a statute of authority for any regulation subsequent to it.
Right, the statute that's being considered, the bill itself, requires a regulation from a board that wants to utilize this new bill if it's signed. So we'd have to end up following up with a regulation anyway. I would caution that the bill says it does not apply to a board that has statutory authority to establish a retired license. That's a little vague. And the board's statute itself speaks to what happens with a retired license. So it's my opinion that because the board has a retired license provision in its Practice Act, that would be considered to have already statutory established authority with respect to retired licenses. So the bill the bill itself, if the board's retired license statute, existing statute, is considered to establish the license for the board's licensees, the board then could only utilize the bill to investigate the actions of any licensee, including a person with a license that either restricts or prohibits the practice of that person in his or her profession or vocation, including but not limited to a license that is retired, inactive, canceled, revoked, or suspended. Yeah. I mean, the regulations that we're contemplating incorporate that. One of the things that was really important to the board members at the last meeting was making sure that the retired licensees understood that they were still subject to the Practice Act. So it seems like there are a few different options for the board to consider. If this bill goes through and gets signed, ? The board would have a limited use of it. The board could move forward with this regulation package with modifications to hopefully satisfy legal's concerns, and the point being there is to streamline the process for when it gets to OAL to resolve most of the concerns before it even gets there. So continue with the rulemaking package for retired license. Or if the bill is signed, potentially look at maybe through the sunset review process, revising the board's retired license statute to include some of these great provisions in this bill, or even repealing the retired license statute to rely solely on the provisions in the bill. Repeal would mean coming back again, though, with another rulemaking package as required by the bill. So, a couple different options.
What are some of the advantages of, or I'm sorry, what are some of the disadvantages of moving forward with the modifications to satisfy legal counsel? Would that be what staff would recommend?
So, the only disadvantage I think in pursuing the regulation at this time is that if we do anticipate any kind of change or trying to take advantage of this new legislation that may or may not pass, that we've maybe boxed ourselves in a little bit more. It wouldn't just be repealing or asking for repealing a statute, but a regulation that had now been either is in the process of or have been approved. There are another thing to keep in mind is, not every statute requires a regulation. We've been processing retired applications up to this point with the idea that that is indeed a statute that allowed us to do so. And I'll admit, I am on the other side of the clarity issue and maybe looking at it from an advantageous perspective. Shame on me for that. But it's also consistent with what the rest of the department would be doing at that point. It addresses some of the issues fiscally that we've identified or administrative resources with an application and fee into status as well as a fee out of status. And it addresses a smaller population of our licensing population.
So I would clarify that if the advantage of moving forward with the current rulemaking package with modifications is that the board supplements its existing statute. Whether or not the board could take advantage of the fee authorization in the new bill is very questionable. The rulemaking package itself could not authorize a fee. That would have to be most likely adopted by statute under the Board's Practice Act.
If I'm hearing correctly, there's two ifs. One is if the bill passes.
Mm-hmm.
The second is, do we even fit into the bill?
If it's determined that whether or not we could use that bill, or if our existing statute creates a conflict that excludes us from being able to use it.
And council saying it looks like we probably don't fit into the population.
Most likely,
Yeah.
the board would be excluded because of its current statutory language.
So it seems that we need to proceed with what we have, huh? Deb?
Well, I'm thinking it also can be a sunset issue
Right.
to bring to the legislature and share that our current state, we've realized that there's some limitations to it, and that maybe we should be included in that, and how they can help us resolve that. I mean, none of this will go quickly, but it may be the most complete thing to explore. So I think maybe if members feel strongly that they want to go forward with language, that's one thing. Otherwise, maybe it becomes one of the sunset issues to explore.
And if it does become one of the sunset issues to explore, then that's where we could kick around the idea of how can we include a possible processing fee.
That'd be one thing. I guess for the committee to discuss and then to bring to the board might be the idea of even repealing the exemption, which would then remove that that confusion as to whether or not we apply. And you could do that using Sunset as a vehicle. It at the will of the board. It depends on what are the most valuable pieces in this idea that you want to be able to take advantage of. So.
And if we wait until sunset, we're assuming that the bill has been signed and we were repealing something that
This bill will be, the determination as to whether this bill passes and is signed will have happened by then.
okay.
So,
Well, and it doesn't necessarily solely rely on this bill, because if we move it to a sunset review process, even if the bill isn't signed, you could still ask for a review and possible revision of the board statute
right,
to
to include
authorize the
similar
fee.
language.
Yeah.
Okay.
A couple of the items in this legislation that I consider to be advantageous are the entry and exit out with a fee. One of the things that we were trying to combat is is creating a limitation to how many times a licensee could utilize retired status. But the spirit of that came from the administrative resource, the draw, that we would want to limit the number of times so that it wasn't overly burdensome administratively. It ceases to become burdensome at that point if they're now having to compensate the board for the processing of that application in and the processing of the application out. So that's another item that you would consider may not be necessary anymore if we went down that path.
Correct me if I was wrong, but were there also concerns that potentially a licensee could use retired status as a way of delaying or postponing paying their renewal fee if they were perhaps practicing in another state? They could retire their California license and not have to do continuing competency and
Right, and
renewal fee.
and we accounted for that in the regulation, but they've also accounted for that in that bill.
How does the board feel about our options?
Well, I'm thinking about extent, how far the bill goes in offer that protection, and it sounds just from what I'm listening is that we may not even be afforded certain of we may not even be part of the bill, right? So that's the first stage. The proposed language is our language, so we set the tone and where we want this to go. And that's a more powerful position as opposed to just relying on the language of the bill and then falling in line with that bill. And now I'm wondering which vehicle is the more effective vehicle. That's probably for everybody.
Right.
Maybe can comment on that
I
to
think-
get the outcome that the most desired outcome that we want for the board.
I think that's an important point. The regulation that is before you today was promulgated with the authority of one of our statutes. So it's within the confines of the authority of that statute. If that bill passes and through the sunset process or whatever other means we use to be able to use that new legislative authority, it's broader. So that regulation would actually have potentially more of what we were looking for to begin with because of the language that's in that statute. So you've essentially written regulations based on a narrower bill, and so your regulation's narrower.
Wow, it seems like to proceed on it would at one level seems almost premature, because then you would want this. I would almost want to have that bill open up and then see which part or how, if it's fully adopted, and then come in with, it's like there's a step before that needs to happen.
And I think there's a potential for that to happen because this bill, the ultimate deciding factor will occur on September 30th when the governor either signs or does not sign it. And so we could still, as a result of either its passage or not passage, plan from that point moving forward, either through sunset or reissuing this package and starting again to use it or not.
I would be more inclined to explore that, just from a strategic point of view, to be in the best position in a long-term view, as opposed to just thinking, oh, I want to have all of this done now or this year. I would look for the best possible outcome long-term, since that's going to affect the long-term more than it's going to affect the short-term.
I agree. I think exercising some patience will allow us to be more aware of our options, and it doesn't seem like this is necessarily a public protection issue that needs to be addressed immediately, and we sort of have the luxury of time to wait.
I just want to make a note quickly that the bill authorizes a fee to restore license from retired status. And your regulation currently says if you would like to restore, you have to pay typical renewal fees. So on some level, that's addressed. On the other hand, revising the statute itself could allow for the retired license status processing fee. And then to restore, you have to do all of the usual renewal steps, such as paying the renewal fee. So it might be worthwhile to consider revising the board statute in any event, because I don't know that this bill is quite gets us there, because I think paying for the renewal fee to reactivate your license is potentially a very important piece of it, in addition to satisfying the continuing competency requirements.
So if we did go that route, is that something that we would look at through sunset?
Yeah.
Okay.
Well, there's sunset, and then there's also, approaching a member in a different bill. But
That's a very good point. If we were earlier on in this legislative session, we would have enough time to approach the author of this bill and see if there was room to somehow fit us in. As an example, subdivisions A and B may not apply instead of shall not apply. Could have been something that might have allowed us into that. We're just not at that stage of this legislative session for that to even be a feasible conversation with the author. But I also think that some of the things that we've done based on the statute and our own Practice Act could be, I think, clearer to both stakeholders and to the board if the statute was a little bit stronger, such as it is in this legislative bill, which sunset would be a good vehicle to explore that option. From an administrative perspective, if we were to hold off the retired status with the idea of looking either through sunset or what other vehicle, it wouldn't have much of an impact on the board itself administratively. Retired status applications at this point are minimal, and we can operate on the statute as we have now.
Are the members comfortable with us incorporating this as a sunset issue to review at the committee level and then make a presentation to the board before our next board meeting? Okay, did you need a motion for that?
No, because it sounds like right now you're just actually tabling this issue to the next meeting, correct?
Correct.
Correct, no.
Just for clarity, we're tabling the regulation agendized today, but we're also maybe adding an item of interest to the Sunset Committee's review.
Yes,
Okay.
but you don't need a specific motion like we didn't need one yesterday to add it to the committee, correct?
Just to clarify, a motion to table would require a vote, and it would require a presentation of an action to be able to table something. But we're just making a decision to not
Take action.
address any action on this item at this time, correct?
This item was actually agendized as discussion and possible board action, so if you wanted-
Possible board action, but no proposed board action has been presented. I don't believe I heard anything, and so,
No recommendation. This is one of those times where we're really looking for the pleasure of the board.
so the use of the word table is typically a motion to table, to delay something, to postpone something.
Mm.
And so we're not actually tabling anything, a proposed motion. We've listened to discussion, and we're not doing anything. We're only discussing things at this point. No action has been proposed.
No action's been proposed, correct?
Thank you.
Thank you for clarifying. Brooke, is there anything additional in your report that we haven't yet to cover?
No, everything's been covered.
Thank you. Okay, moving to agenda item number 20, the Administrative Services Report.
You guys can sit together.
We can sit together.
Good afternoon.
Good afternoon. Can you guys hear me okay?
Yeah.
If you would introduce yourselves.
Oh, hold on. My feet are dangling. I can't. Liz Constancio, Administrative Services Manager for PTBC. I'm reporting on the budget report.
And Carl Nelson, Administrative Analyst for the board.
Good afternoon, board members. Robert Delastreas, DCA Budget Manager. Happy to answer any questions you may have regarding your budget or your fund condition today.
So I'll start. Sorry, we're trying to. Okay, we're tag teaming. Okay, so the information provided today is going over the activities for the fourth quarter. However, with the fourth quarter being the end of the fiscal year, there were some things in here in regards to highlighting all of the quarters. So the budget report was updated. And also, I wanted to clarify in the memorandum, in the materials that you were provided today, there was, let's see, the third paragraph down regarding the application and licensing fee schedule that was effective May 6, 2016. I kind of wanted just to clarify and kind of recap how we got there, just for the public. Again, the statement being this action was necessary to avoid financial insolvency. So at the beginning of this fiscal year 15-16, the PTBC reported a structural fund imbalance, which was a result of our application and licensing fees didn't sustain our ongoing operational costs beyond budget year 17-18. Sorry, I think that's like the 10th on my side. And so again, I just wanted to clarify that because it was kind of vague. And for those that haven't had the opportunity to follow us all year, I wanted to make sure that I make that statement. And so that's where we're at right now. We were successful in the fee increase, and it was implemented May 6, 2016, and which is during our fourth quarter. And I don't have anything to add to the memorandum at this time or ask if any action from the board members. Unless, Carl, if you have something to add.
No, I don't have anything.
So if we go to, let's go to the budget report, revenue statistics report, and that should be page 101, attachment 1. And so, as illustrated, the PTBC collected $813,000 for the fourth quarter, and $3,849,261,000 year to date. For this, I'm going to say fiscal year being the current fiscal year. That's what we reported on, which is 15-16. Sorry. In the report, so for fiscal year 14-15, the PTBC collected $883 for the fourth quarter and $3,514,272,000 year to date. As the report shows, there was a revenue increase by $127,937,000 over previous fiscal year 14-15 during the fourth quarter, and then a year-to-date increase of $334,989,000, which is the 9.53% that you see on the report. Did you have anything to add?
I think that increase can kind of give you an idea of what the fee increase is doing for us, because we did collect some in the final quarter. We started to collect monies based on the fee increase.
I have a question for you. With the fee increase now in place, do we still run the risk of insolvency?
That's a really good question, and right now projections show that we do not. At the beginning of the fiscal year, we had projected insolvency in 17-18. We were at approximately negative 3.7 months in our fund condition. You can see I'm looking at Robert going, 3.7 months in our fund condition. And with the revenues collected this end of the fiscal year, we are now at 2.9.
2.9, that's great.
2.9 months in reserve.
What's a healthy number of reserves that the board is aiming to achieve?
So I'll add to that, or I'll answer that question. So there's really no target in law to kind of identify what a healthy reserve is, but a typical target we like to see our programs have is around 3 months of operating months in reserve.
Robert, would you consider that to be a minimum?
I would say so. I mean, you could have a range 3 to 6, but 3 is usually kind of the sweet spot we like to have our programs at.
Thank you.
Yeah.
Below 3 months necessitate a fee increase?
It necessitates to reassess your fund. It's something we do with the program every year. One of the things we do is build the budget in the fall. And one of the major components of building the budget is that we have to reassess the revenues that we're currently projecting for the program. So this upcoming fall cycle, we're going to go ahead and do that, work with Carl and Liz to reassess your revenues. As you can kind of see when we go to the fund condition, the current projections are very conservative. A lot of the revenues are static. So in addition to that, the expenditures are projected to be fully spent in regards to not accounting for any savings you may have each year. So with those two being said, I mean, it may skew the projection a little bit, but that's why we want to revisit it every year, so it provides you more of an accurate picture every time we look at your fund condition.
So for the purposes of the fund condition that's displayed as an attachment here, it's fair to say that both the revenue and the expenditures are very conservative in the sense that they're almost doomsday scenarios, that it's static in revenue. It's not projection forward for any kind of increases that you might have. We're just going to say if things stopped today, we could rely on this revenue for the next 3 years moving forward. And conversely, for expenditures, we do know we are projecting increases in expenditures as a result of things like pro rata and other state expenses. So really, that display is cautionary. It's really there to tell that tale. It may not exactly paint the reality of the matter, but it is it's like when you're planning for a worst case scenario, that display would be very helpful.
And to add to that point, we also provide a 2% increase in your expenditures to kind of mitigate some of the uncertainties we may see in forecasting your spending.
Yeah.
So that's another thing that we provide you guys in this fund.
And I guess essentially that's my point, is in that display, we've put every possible negative in the expenditures to be accounted for, but we haven't put every possible positive in the revenues to be accounted for, just to be safe in both directions.
That's
And that
correct,
includes
in the
like fixed
projections.
costs, like staff increases in pay and
Correct.
benefits and things like
But
that.
it also, and for as far as revenue's sake, it also doesn't anticipate any growth of the licensing population that might result in a revenue increase. That's not part of the projection that you see in the attachment. That's why the revenue for renewals is static for the next 3 years.
So since we've gone to that, then why, if that's kind of the projection, then why does our expenditures look the way it does on the fund condition analysis? It goes from 4.2 million to 5.2 million.
So in comparing those 2 years, the year you're looking at, the 4.2 million, is actual expenditures being reported. As of the year that you're comparing it to, it's the full budget. So with that being said, 1 year you may have lower costs, the other year you may have a bigger budget, but the year that you're looking at, the 16-17 with a higher budget, it doesn't account for any savings. So the lower number does, it's an actual number. So with that being said, in the materials you saved roughly $100,000.
The biggest discrepancy that I could identify between the 4.2 and the 5.2 is the 3 additional BCP positions
That's
that we
correct.
received.
That's right.
$1 million?
Well, so those numbers don't include just salary. They include things like square footage and equipment and benefits and
Pro rata change.
and also increases in pro rata are
At
also counted in.
Salary increases, benefit increases.
That 2% that he had talked about as anticipation of cost increases is also in that number.
Right. It's what's that's in the Budget Act for 16-17. So it'd be this current fiscal year, and our budget authority increased by $997,000, and part of that was for BCPs, which was 518, and then the other 479 approximately was for the other line items. So things like the staff benefits.
And so if you look at the increases between fiscal year 16-17 and 17-18, they're nominal. They're about $100,000 difference because there's nothing at this point anticipated that they could use as a projection increase in staff or anything like that.
That's correct.
Right.
This also does not include, though, the increase in revenue that we're expecting, I think, as of our workload revenue that we will be turning in at the end of the year. Correct, Robert?
Yeah, so to Carl's point, that's kind of the exercise we run with the program is they provide us a workload revenue document that we use in order to project revenues moving forward. So we usually do a 3-year average of kind of the workload that they provide. The workload being how many applications was processed in terms of initial applications, renewals, as well as projecting kind of the cite and fine you brought in, and using the last 3 years and projecting out for the next 2.
And if there's something that the board members are interested in seeing, we can definitely provide that information at the next board meeting. So if you want to see a comparison or maybe two different types of fund conditions, we can do that.
The only thing that I'd like to note is that, just as a reminder, that there's a collaborative effort between PTBC staff, essentially Liz and Carl, and DCA budgets to continually revisit this issue and provide new data to update these projections and keep an eye on what that fund condition actually looks like.
Is it possible to get a non-doomsday scenario fund condition projection that actually incorporates
An optimistic.
an
fund condition?
not necessarily optimistic,
I
but
would caution in that. I think this is a better way to plan because there are no guarantees, and I would not want to put all my eggs in one basket, if you will, and try to anticipate growth and those kind of things and show that. I think that, and that's kind of the reason I made that remark about collaboration, is that this document will refresh month after month as new data is provided to Robert's staff, and you'll see that, hopefully in a more optimistic view, that 2.8 for next year increase as a result of the data that we provide him showing that actual revenue received as a result of the fee increase.
perhaps I'm asking that because in the sunset review process, we're considering raising the caps on our fees. And it would be helpful to base whatever number we come up with on past trends of increase in
Absolutely.
applications and licensees and et cetera.
And that's the only other point I would make is that this is a much more compelling argument
Okay.
to make to the legislature that it would be necessary at that point.
Okay.
So I'll just ask the dumb question, which is I think the thing that concerns me, and I realize it's doomsday, and I realize kind of the incomplete information, all the assumptions that are made in it. But I think the thing that concerns me is just in black and white seeing that we just approved fee increases because our operating was getting close to not being matched by the revenues, but the budget expenditures will go up by 20% in this. That's very, I don't get it. Like I'm
Yeah,
bothered by
it's
it.
topsy-turvy. I mean, it's a different methodology for expenditures than it is for revenue. Internally, our staff can provide what we, our best case projections, with the data that we have provided, and we can include that in the next report.
And we do keep that information internally, just so you know. We do have fund conditions that we do in-house.
As part
so
of
that
our
we
just
can,
day-to-day planning.
yes, that we watch very closely to see, where we're at. And they are based on a 3-year average projection ratio. So whatever we received as far as number of applications, we do the average out. It's just a simple math formula that we do and what we expect or what we project to receive the following fiscal year. And again, that's not what's included in the fund condition that the budget office provides to us. We have a better idea of what we're going to spend than what we're going to get. Does that make sense?
They say there are certain things that are certain in life.
There you go.
Death and taxes. This is another one of those things, is we're certain that the expenditures are going to increase.
Yes.
We have a very good idea that the revenues are going to as well, but not as certain.
So with new efficiencies like Breeze and things like that and other processes that have been refined, is that also factored into the expenditures as far as staff and things like that?
No, not necessarily. Only in that Breeze at this point is a cost, and it has not had enough time running to be able to determine whether it's a cost saver. I mean, we had the cost of deployment and development that we absolutely paid for, and we can indicate that cost. But the program will have to be up and running for some time before we can start to see the efficiencies or the costs that it realizes in lessening our expenditures.
Are we tracking the progress it's making or the impact it's making on staff time and resources?
Day to day,
Okay.
yeah, without a doubt.
Perhaps a year from Breeze's launch, if the board could get a report.
Sure. In fact, it's anticipated in the next actual board meeting you'll have more statistics that are Breeze oriented. As an example, the number of renewals that are processed online through the Breeze system in ratio or in a percentage based in the total. So you'll see how many people are actually utilizing Breeze.
That's great. Thank you. Any other comments from the board or any questions? Okay.
Good.
Anything else to report on the budget? That was it?
No, unless you have
Okay.
any other questions.
I'm not hearing any. We appreciate it. Thank you so much.
Thank you.
Thank you,
Thank
Mr.
you.
De Los Reyes.
Thank you.
Moving on to the Consumer Protection Services Report, agenda item number 23.
Hello,
Good afternoon.
Elsa Ibarra, Consumer Protection Services Manager. So I will kind of piggyback on Sarah's comments with regards to Breeze. Enforcement is also with Breeze doing all the enhancements and improvements that are needed. And as we go along, we find things that are missing or need improvement. So we are implementing those improvements and then as well testing, constantly testing on new things that we're adding onto Breeze for the processes. And then I'm going to go ahead and refer you over to page 123 of your agenda book. And that's the statistics report. And this one is basically data from all levels of the enforcement program, from the time a case is initiated to the time that it's closed. This spreadsheet was revised, and hopefully it'll be more helpful to you so that you can see the changes from fiscal year to fiscal year, or, well, like Liz was indicating, we are at the end of the fiscal year, so I gave you a whole year's worth for 15-16. So we're comparing it to last fiscal year, 14-15. So this will show you where the increases are, the decreases are, which I think will be very helpful for you to see where we're at in comparison to the year before. If you look at the desk investigations, the average time for fiscal year 15-16, we were at an average of 105. So that did decrease from last year, which is good. But I do want you to know that although we have these performance measures goals and we want to meet our goal to complete an investigation within a certain amount of time, we don't jeopardize the investigation at all. We want to make sure and we have a full investigation, a thorough investigation, so we're not going to limit an investigation to try to meet those goals. If you go to the next page on 124, total disciplinary orders, there too, we've decreased our time for fiscal year 15-16. And then on page 125, the next page, which is all of the performance measures, the 4 PMs. The first and second aren't really, I think we've talked about this before, there's not really a goal to meet. The first one is how many complaints are initiated. The second one is the convictions as to how many convictions have been initiated. I do want to point out the last 2 fiscal years, convictions have made half of our complaints initiated or cases initiated. For PM3, these are cases that were investigated but had no discipline taken. There too, in comparison to last year, it did decrease a bit. And then also in the PM4, these are cases that actually had discipline taken, so that's the time the case was open to the time that the final disposition went into effect. That one also decreased. At last board meeting, some of the board members requested additional information with regards to the type of complaints that are initiated. And so on page 120,
7.
are your different types of categories that are open. So I gave you the last, the 5 years. So it gives you an idea of the type of cases that are initiated and received. And then going back to page 126, one of the other things that board members had requested was just a milestone as for the last 5 years for all of the performance measures. And then, like I said, for the last 2 fiscal years, convictions have made up half of the cases initiated. On PM2, where on the average days for intake, there's, it's 15, the number's 15 for average days. But looking back into that, that was there was a transition in staffing, new staffing and new duties. And so as soon as we found the errors and the way it was being inputted into Breeze, or into CAS, I'm sorry, that was Legacy, we went ahead and corrected it. So that was the reason for the high average. Is there any questions?
This 5-year look is really, it's really helpful.
Good.
You kind of forget year to year.
Yeah.
It's really helpful to see things that stay similar and things that have really improved. So that's good.
Elsa, I had a quick question. I agree, the spreadsheet looks wonderful. My question is, on these categories, the largest number are in the category that we're calling other. And are we, just a very simple question, with so many in the category that just, these things don't fit in any other category, are we bound to these specific categories, or can you add categories?
These,
Can you group them in any way?
well, yes and no. Throughout DCA, there's certain categories that you have to use. So these, they are DCA. They're across the board. So we do have to use them. There's other areas within Breeze. And again, like I said, this is at the time that the case is initiated. So it may start off as other, but then it may go into something different once we find out and figure out what we're actually investigating. And in 11, 12, 12, 13, there were a lot of address change issues that we were looking into. However, because of the time and the resources that it was taking, we found that it wasn't as important as to look at our other complaints that actually had allegations, violations, other types of violations. And that's why that number has gone down as well.
The other important, and I think it goes to your point, is that with the implementation of Breeze, we did create other pigeonholes.
Okay.
So the best example is address changes. There's actually a category in Breeze for address or name change violations. So that higher number, that 1268, that was the old legacy system, and that was the only category we could use in the system. Moving forward, you'll see that it's even changing already with this fiscal year and moving into Breeze.
Good. Thank you.
And there were a few other categories, I didn't include them, that have been added into Breeze.
Where are DUIs being captured in this categories chart?
DUI, right now, DUI isn't captured on.
Oh, I'm sorry, DUIs.
Oh, I'm sorry, DUIs?
Criminal.
Under the criminal.
What if it's a DUI and unprofessional conduct? Where would it go?
We'll usually put it under the conviction.
Okay.
But then once again, once you start investigating and you find out exactly which ones.
We would defer to the most clear definition. And so because it's a criminal conviction at that point, I think that's where you'll see it categorized as that statistic.
Got it. Thank you.
And unprofessional conduct really is anything.
Yeah.
You know, it's, yeah.
Can I ask a question? Back on agenda page 124, the disciplinary actions table.
124? Uh-huh.
At the very top, the AG cases initiated, is that any time an accusation is filed?
No, this is just any case that we forward for their review.
Their review?
Yeah, a good majority of that statistic would be accusations filed, but in the event that the AG refused to file an accusation, that's also captured here as well.
And that number is much lower.
Yes.
Mhm.
And then, but then again, you know, the number of complaints being received are lower.
Okay.
The number of cases going to DFI are lower. So it's just all trickles down.
And it wouldn't be affected by things that are now being desk investigated, because those could end up at AG.
Still could, but they could be affected by it. Because the priority matrix of what goes to DFI has changed is also part of the influence. So cases that might have been sent to DFI and been handled through the AG's office before can now be handled either through the citation process or through an in-house public letter of reprimand or something like that. So while it's a cost savings in AG, it also affects this statistic.
In that same chart right there, what is SOI?
Statement of issues. Statement of issues is when an applicant has been denied and they appeal the denial. So then it's forwarded over to the Attorney General's office.
Okay. Okay, and then on the previous page on 123, you've got it sectioned out into desk investigation and field investigation. So the field investigation is the DFI, right?
Those are cases that are worked with DFI, yes.
Okay, and the desk investigation is everything we took care of, staff took care of in-house. And I know that some things you can control and some things you can't, but average days to close for 14-15, 139, and then by the end of this year was 105, so it did go down. Do you have any idea why? I mean, you mentioned that you are very thorough, and I trust that staff is thorough, but those numbers look pretty good. I mean, like Q3, that's a little bit up, and maybe that was a case or a few cases that we had no control over, of it being in limbo somewhere, but in general, the numbers look pretty good. Or is that just part of the roller coaster up and down?
It very much is. I mean, it's hard to put all these numbers on the same page and keep them in context because
Yes.
that's a day range.
Yeah.
So if you think of 140 versus 91,
Yeah.
it's not as, you could definitely see where an investigation of one case might take, 2 months longer than it would another case. And so it is very much variable dependent on each case. And again, I think a little bit of that is a priority matrix too, where staff has now taken some of these cases and handled them at the desk level and determined that they don't require actual, sworn peace officers to participate in that process. So that definitely cuts down on the day range too.
If you look at, on the bottom of page 123, the all investigations aging, that'll also give you a better idea of what's the percentage of cases that are closed within a certain amount of time
But that's desk and field put together.
together.
Yeah.
Mhm.
And because we are the size that we are, statistical weight is very much kind of part of that conversation. So you could have an egregious case, a sexual misconduct case that requires an extensive investigation, and that one particular case may skew the statistics because of its own weight in consideration of a case that you get to open it and within a month you've determined that it's even non-jurisdictional for that matter, and you turn around and you close it a much smaller statistical weight. So this is definitely an exercise in statistics.
Does the board have any further questions for Elsa?
Is PM3 also just desk cases?
PM3 is everything.
It's everything.
Well, So long as it doesn't have discipline. It didn't go to the AG, so it would just
Yes.
be desk and DFI investigations.
Okay, it is both.
But it could involve DFI.
Okay.
Right.
And there are times where there are factors that are they're not appropriate to try to reveal through the desk investigation, so we employ DFI, only to find that there's really nothing to find. And so, but we are being diligent in our pursuit of the investigation, so we require their services.
How long have these measures been in place?
Since 2010.
10-11 is when they started.
When are they going to look at them again?
They're actually in the process of looking at them now. So, and I think you're asking more, maybe a more specific question as to when they might be reassessed. Yeah, that is happening now. What that reassessment looks like, I don't have any insight into as of yet.
Thank you.
Hearing no further questions from the board, is there any public comment? Thank you,
Just one
Elsa.
more thing I'd
Sure.
like to just heads up to board members. Breeze has the capability of the voting system for your cases. Instead of you emailing your votes to us, you'll be able to do it via Breeze. Last I heard it was not working, so I'm looking into it because I heard it is working. So just heads up, you may or may not receive an email that we're ready to go, and then we'll give you more information as to how to get into it to do your voting.
What's the security like on that?
It's supposed to be okay.
Allegedly.
We did bring that up during
Okay.
pre-breeze.
Okay.
And they said it was, we should be okay.
Okay. Do we need to create a Breeze account to vote, or is it via email?
I'm not sure, to be honest with you.
Okay.
But I will get more information if it's ready.
Okay.
So
Also, just looking ahead, I imagine there'll be a little box or something for our comments, like
yes,
you usually
definitely.
request?
Yeah. And if it doesn't work out, we can always go back to email.
All else fails, right?
Exactly.
But what are the advantages of having our votes on Breeze?
I think the advantages is that you'll be able to, or we will, on the back end, be able to just go ahead and connect it to the case that it belongs
Oh.
to. So, better track. And I think, if I'm not mistaken, I think it'll also keep track of who's voting. So it'll all be tracked.
Is there any board comment on the vote by Breeze issue or potential opportunity?
Potential.
I think Elsa has just one other highlight, and that is she's losing a very tenured analyst to retirement. Well, in a couple days.
I know.
So Karen Thompson, who's been with the board for 21 years, is retiring, and her last day in the enforcement unit will be September 2nd. So we just say thank you for her service and be jealous of her retirement for now.
Yeah, Breeze can't replace her.
No.
Thank you, Elsa.
You're welcome.
And thank you to Karen for her service on the board. Let's take a short 10-minute recess and reconvene at 2:18 p.m. We are back from recess. The time is 2:18 p.m. We are moving to agenda item number 24, probation monitoring report.
Good afternoon, everyone.
Good afternoon.
Well, my name is Monty Martin. I'm the probation monitor for the board, and I'm here to give you the inaugural probation monitoring report. We have not done this before. It's a new thing, so hopefully you guys will like it and have questions that I can answer and give you further stats in the future if you should want them. My plan is to give you some basic stats and then let you ask questions. Like I said, if you refer to attachment A1 in your agenda book, you'll see a chart there, and it's got the end stats for probation for the 2014-2015 fiscal year. And it also has the 2015-2016 fiscal year broken down by quarter. Currently, there are 104 licensees on probation for various causes, from aiding and abetting to driving under the influence. Of those 104 on probation, there are currently 12 that are tolling. That just means that they're either out of state or they're still in state but not practicing within the profession at the current time. Of the 92 licensees that are not currently tolling, 23 are enrolled in and participating in our drug and alcohol recovery monitoring program, equaling 22% of all licensees on probation. At the same time last year, the board had 88 licensees on probation, and then 11 of those 88 were in the board's drug and alcohol recovery program, or 12.5%. That's the basics of the program. Did you guys have questions?
Can you share what a visit with the probation monitor is like?
A typical visit? Well, if I have time, I will come out and visit with you personally. Most of the time, it's by phone now. Basically, for a standard quarterly report, I'm just going to go through all of your terms and conditions with the licensee, all of their terms and conditions, and just assess how compliant they're being. I also speak with their supervisors to find out compliance. The supervisors submit reports. The probationers submit quarterly reports as well. If it's the initial interview I'm having with the probationer, that's a little more involved. I'll go over each term of their probation with them in detail, make sure they understand every aspect of their probation. So that's the typical.
And so quarterly, you are kind of reviewing with them the terms of their probation?
Each quarter we go over all the terms and figure out whether or not they're being compliant. Answer any questions or concerns they may have.
Other than figuring out if you have time to make a face-to-face visit, is there anything or any other condition that might push you to have a face-to-face
If I had
visit?
concerns about their compliance, yeah. If
okay.
they were consistently incompliant, either not returning paperwork or just not doing what they were supposed to be doing, that may elicit a in-person interview.
Yeah, in the last two cases that we just reviewed, that was pretty important information when I saw the investigation and you talking to those folks. So I have a question about, when you're doing those interviews, do you get a sense of, when someone else is talking about your probationer or someone that is under your care, do you get a sense of what's really going on? Because why I'm asking that is because in the one report, the person that you were interviewing, it was more like it felt like they were saying one thing and then saying another thing towards the end of the report. And I was wondering if that always happens.
For that process, I would say most of those interviews go the same way. And for me personally, I don't get a lot out of them. Basically, it's people that have agreed to write letters of recommendation. They know them, so they're going to be pretty positive most of the time. When it catches my attention is when they say something that's not always positive or something that I didn't know. That's when it kind of piques my interest, and then I'll delve into that further with more questions. But some of those people I don't even know that well. So I do investigations for when they petition for reinstatement, and those people aren't on probation with me. They're just people that have been revoked and are petitioning to get their license back. So I may not have any information on them before I actually speak to them. I don't have any personal relationship with them before I speak to those. people that have been revoked.
The general advantage of having that face-to-face interview, though, is to kind of just fester exactly, I think, what you're trying to point out, is that you could have a written report and even a telephonic phone call, check-in quarterly, that kind of thing, but there is no better input than face-to-face, where you can take other considerations, other things into consideration, like body language and statement analysis and those kind of things. And when I came to the board in 2010, Monty had about 60 probationers, I think, and so the actual workload is almost doubled. And having to monitor that number of people, it's very hard to keep up that travel schedule of going out and doing periodic face-to-faces. It's something that we'll have to visit at some point and determine whether or not a second probation monitor is required. But that is the general idea in just compliance and probation monitoring, is that take into account what they're telling us, but also have observations to provide judgments for us as well.
Does the potential restructure account for an additional staff member in the probation program?
It could certainly help.
Okay. And since you are our sole probation monitor, is there any inconsistencies in orders that the board writes that make it difficult for you to have the flexibility to work with the probationers?
Sometimes it's really hard to come up with terms that work for everybody. You know, you never know what's going to happen in the real world when you go out there. We may write terms that we think are good for everybody, probationer included, something we can live with and something they can live with. And then when it is put into effect, we find out, well, it's really hard for that person to get a job with those terms, or supervisors just won't, or companies just won't take a chance on that person just because they're on probation. So it doesn't really always matter what we do, what the order says. It's just luck and circumstances a lot of times.
Thank you.
I'm wondering, with newer technology, almost everybody has a smartphone of some type. And I'm wondering if you've tried to either Skype or FaceTime or do some sort of a video call to try to get more of a face read or body language read.
We don't have those capabilities as far as I know.
Well, it's not. That's part of it. Part of it is the technological know-how on our side of the fence, but the other part of it is there's nothing actually in the order that requires the participant to do that. So the language is broad enough to require the response to a face-to-face appointment, but not to incur the expense of making sure they have that software with that smartphone or that laptop or anything like that. But I think you guys know me well enough that it's not that it hadn't been thought of before, because it's just when you try to apply that kind of technology to this 106 or 104 different license types or different probationers, it doesn't work out all that well.
We actually just spoke about that maybe like a month ago.
Yeah.
Any further questions from the board? I just want to comment, I love the inaugural report. I would love to see this at future meetings as well.
Oh, great. And if you guys have any other questions or things you would like answered during these reports, please let me know and I'll be happy to include them.
Absolutely. Thanks, Monty.
Thanks.
Moving on to agenda item number 25, any public comment on items not on the agenda? Hearing none. Agenda item 26, any agenda items for future meetings?
And to clarify, I believe it still says the 10th, the 9th and the 10th, and that should now read the 16th and the 17th, correct? Okay.
none from the board, and
Sorry.
go ahead.
Something that's an issue that's been raised in the past and has come to a little bit more attention recently is about if there's something that we can do to look into the quality of the continuing education courses that are being presented, and also addressing the way that courses might be taken and approved so that they're presented. We've seen them on occasion presented to us, but I'm wondering if that could be something that we could consider looking at.
Any other items from board members? Any public comment? At this time, we're going to move into closed session to discuss the executive officer's review, and we will reconvene back into open session in about 15 minutes at 2:46 p.m. Thank you. Back on the record, the time is 2:56 p.m. Is there any additional public comment before we adjourn? Hearing none, the meeting is adjourned.